Dr. Sleep, according to IndieWire. Now, Variety confirmed the movie is adapted from Stephen King's sequel to The Shining, which Stanley Kubrick adapted into one of horror's most iconic movies in 1980. Danny Lloyd famously played the role of Torrance in Kubrick's film. Now, Dr. Sleep picks up with Torrance years after the events of The Shining. The character is now a rage-filled alcoholic whose shining powers return when he begins to embrace sobriety. Torrance starts using his gift to communicate with the dying at a local hospice center, and his story takes a turn after he meets a young girl who also has shining powers. Now, in other news, Kenny Chesney is donating all proceeds from his new album to the Virgin Island Relief. According to the amazing story out of Rolling Stone, Kenny Chesney has announced the track list for his new album songs for the Saints. The album is due July 27th. Now, Chesney, who is a part-time resident in the Virgin Islands, is putting his money where his mouth is because all those proceeds from the sales of the album will benefit the Love for Love City Fund for Virgin Island Relief. The region is still recovering from Hurricane Irma, which decimated the island's community back in September. Chesney said this in a statement, quote, "To me, it's about the hope, the strength, the joy, and the courage they are bringing to the task of rebuilding after a kind of destruction no one has ever seen before," end quote. Chesney founded the Love for Love City Fund to help provide relief to those most in need in the U.S. and British Virgin Islands, ensuring the aid is funneled in the right direction. And that is your entertainment wrap-up for NBC News Radio right here on KCAA. I'm Andrew Caravella.
Whether you swing a hickory shaft Massey Niblick or the latest titanium hybrid, golf is your game, and the Boy Scouts need you. To be specific, the California Inland Empire Council of the Boy Scouts of America need your help in joining them for their 10th annual Golf Classic at Los Sureños Golf Club in Chino Hills on Friday, August 10th. A continental breakfast and a lunch are included, and we tee off at 7:45 a.m. Proceeds will help to offer young people responsible fun and adventure.
Erin here from On the Brink Morning Show, where we talk about all that is engaging in the Inland Empire. News, politics, business, family, things to do, and so much more. Join us weekdays from 6 to 7 a.m. on KCAA 102.3 FM, 106.5 FM, and 1050 a.m. or on KCAAradio.com.
KCAA Loma Linda, your CNBC news station, where your business comes first.
And now, it's For the People with Judge Herb Dodell.
Well, good afternoon, ladies and gentlemen. I just found out that, we had an interview with Roger Stone a couple of weeks ago. I thought it was very interesting. I thought he had an interesting perspective. I didn't agree with a lot of what he had to say. But it was interesting, and I read today that they're investigating him for a meeting with the Russians in May of 2016, where somebody asked him for $2 million, and they were going to give him a whole lot of stuff dealing with Hillary Clinton.
A Russian operative.
A Russian operative.
Whatever the hell that is.
You know that lots of things were going on that we're going to learn about as time goes on. But it was interesting that we had a guy like that on the show, because people have been calling me and getting in touch with me saying, how'd you do it? And I said, it has to do with my man. There's no way I'm doing this without Gary Garver. So
thanks, Judge.
He knew somebody who knew somebody.
I know people, Judge.
And you did. And last week we had this great interview, I think, with Scott Ross. I thought that was fascinating.
Yeah.
And I've been thinking about it. If I was an appellate lawyer, I think you got a shot of winning this for Cosby.
Well,
I really do think so. It depends, of course. I don't know all the facts, obviously.
Well,
but if what they're saying now is true, there's a constitutional issue here that might get this guy out.
Well, can I tell you what happened last week? That Bill Cosby on Friday fired Tom Mesereau.
Yes, I heard that.
Did you hear that? Okay.
Yeah.
And which Scott Ross worked for. Scott Ross was a private investigator. Actually, Scott's doing his show, starting the show this Thursday, 9 a.m. And guess who he's having on? Tom Mesereau.
Oh, that's interesting.
To discuss the Bill Cosby trial. Now that Tom Mesereau has been relieved of his duties, he can discuss the Cosby trial.
He can discuss the trial, but he can't really discuss anything that he talked to Cosby
Well,
about.
no, I mean,
Well,
lawyer-client privilege.
it's very interesting. Every now and again, client decides whatever's going on, they're going to make a change.
Yeah.
And they think that making that change is going to make a big difference. Most of the time, unless the lawyer was incompetent or really failed to do the job right, very little change is going to take place. I can tell from the record, the existing record, which is mainly what's been reported. One could argue that he should have kept out the prior acts. But that's a judicial decision that's made based on discretion.
Can I ask a question? What about the deposition? That's what really fried Cosby. Did I say Crosby? Cosby.
The answer to that is that the mistake that was made early on. It was made by the prior lawyers, whoever was handling the civil case at the time.
Oh, I'm sorry, Judge.
Showtime.
Oh, jeez, my phone is on. I'm sorry.
I just turned mine off.
I'm sorry. See, I was wondering what you were thumbing for, and then all of a sudden my phone
That's what I was
goes off.
thumbing for. I said, wouldn't it be embarrassing if all of a sudden,
listen, I always have my phone off.
My phone is
Sorry.
My ring is a duck call, and so you're sitting around sometimes, and all of a sudden, quack, 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 quack. In fact, the other day I was sitting outside, and there were some real ducks, and I ran to get my phone. I couldn't tell the difference.
Oh man! And so lo and behold, they just called me back again. Please, well, I guess I'm not listening to the show.
The bottom line really is that the proper thing to have done at the time, it's always at the time. You always think 20/20 hindsight is always brilliant. He should have gotten a waiver of some kind and an assurance that the statements that he was making in a civil case could not be used in any later prosecution. And if it's true that was the warrant, he said, you can say anything you want in the civil deposition because we're not going to prosecute you. And he does. I never would have let him do it, but he does, and he makes these statements. He was induced to do that by prosecutors, and that could rise to a level of prosecutorial misconduct if the prosecutor had anything to do with the release of the information. May very well have been by some federal judge just decided to release it. I can't imagine why, if there was an agreement that was made between the parties beforehand. Can't imagine why anybody would release anything. It's the equivalent of a confidentiality provision. In fact, I was dealing with a confidentiality provision not too long ago and said, what if they breach it? And it all gets out. You have no real protection.
Yeah.
What do you got? An argument against the person who signed the agreement that they didn't honor? Where are you going with that? If you've admitted something on a public record, which is an admission,
right,
and comes in as an exception to the hearsay rule, comes in, that's marginal conduct. So I don't know what Mesereau did, but they got that testimony in over, I'm sure, proper objections. You have to make an objection.
I'm sure he objected.
I don't know why you can't blame him for the judge's rulings.
No.
The problem is that many clients will blame the lawyer for the judge's rulings. Well, it's amazing.
Well, he got off the first time, so of course he's upset because he got nailed this time. So
well, he didn't get off. It was a hung jury.
Lo and behold, the hung jury. So this time he got convicted. So he's upset, and he doesn't want to go to jail. So he wants to find another lawyer, probably figure something out.
But what Scott said last week is they had an appellate lawyer sitting there, so they were building the record all along anyway. Whatever that record is, the new lawyer is going to inherit it.
Yeah.
And if he does great and he wins, he'll be the star and the hero. And if he loses, he'll say, you know what, I did the best I could, considering the guy that was here before me didn't do a very good job. It's a no-lose situation for Mesereau, really.
Well, Mesereau's off the case now, though.
Yeah, he is.
So, whatever. He's done. It's over.
But, you have to think about the comments that are made by, I'm calling them prior lawyers. You want to justify what you did, number one. And you want to justify what you did by showing you specific instances, which we're going to do this today, matter of fact. I'm going to talk about trials today.
Okay.
Because the questions that I've been getting and the inquiries I've been getting are really how do you try a case? Every case, of course, is very different. So we can divide them between the civil and the criminal because they're very, very different.
Completely different, right?
Oh, day and night.
And especially and the preponderance of evidence and the conviction type thing, because you just need a little bit, like with OJ. The classic thing is OJ Simpson, where he was found not guilty, and then they found him guilty in civil court.
Well, you deal with the same concept, and I've mentioned it from the beginning. It's called the burden of proof.
Right.
And if you don't know at the end of a trial, and you're the judge, and you don't know who to believe, it's a he said, she said, whatever it is, and you can't find any direct or convincing circumstantial evidence, it's got to go against the party that has the burden of proof.
Right.
And sometimes all you need to do, in fact, as a lawyer, what you do every time in a criminal case is you establish what's called reasonable doubt. Poking holes at the prosecution's case, putting on the evidence that you have that creates that doubt. What witnesses are you using? Are you using any witnesses at all? Sometimes the best defense is I rest, and hold the prosecution to the burden of proof.
Right.
So you know what? I've listened to this trial. We're not offering any testimony because we don't have to. In fact, in the criminal law, defendants don't have to prove anything.
Can't they also, like after the prosecution puts on their case, the defense can actually say, hey, they have not met the burden of, reasonable doubt or beyond a reasonable doubt, correct? Can't they?
Yeah, it's called an 1118 motion. And you can do that at the conclusion. It's the equivalent of a non-suit in a civil case. We heard all the evidence. It doesn't rise to the level of a conviction by meeting the burden of proof, which incidentally, I'll mention it again, criminal cases beyond a reasonable doubt to a moral certainty. That's the magic language. Civil case, more reasonable to believe it than not, more likely than not, that the evidence that you have is as good as, if not better than, the evidence being offered by the other side. It's all about creating doubt.
Right.
Good lawyers do that, and it was interesting. We'll talk right after the break because I hear that music in the background. By the way, I had breakfast with the guy that wrote the music the other day.
What's his name?
His name is Seven Reyes. He's got the hit song on Kanye West's new album that he wrote in my house.
Well, we should play it on the show one day.
Okay, maybe I will.
All right, cool.
It wasn't my kind of music, but it was, it was certainly interesting.
That's not my kind either, but we can still play it.
Yeah, we can. He's good. Someday maybe we'll have him as a guest.
That'd be cool. Okay, we'll be right back with the judge.
1050 AM, KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, welcome back. We have this little break, I don't know how long it runs, maybe 2 minutes. I'm always entertained because Gary always says something with that infectious laugh that gets me going. But, somebody did call me the other day and was asking me if I would do a show somewhere. So I said, well, I would like to. I said, what have you heard so far? She said, well, I've been listening to your shows.
Really?
And what you do is you demystify the legal system. Demystified. Is it really a mystery? It is for most people.
Of course it is. We're scared. Well, I was going to swear, but I can't. It's FCC regulations here. But you're scared when you go into the court.
You know what?
Man.
The biggest problem is that a litigation, civil or criminal, truly takes over your life.
It's scary.
When people get into it, whether they get arrested for something and then wondering about if they're going to go to jail or whatever it is, or whether you're in a civil case and they're looking to take, your shoes off without touching your socks. And it's a serious issue. It pervades your life for sometimes years after years. The one case that I took to the Supreme Court, it took 13 years.
Wow.
13 years.
That's crazy.
2 trips to the Court of Appeals, and it goes on and on and on. When I was a young lawyer, and you fill with all that piss and vinegar, you go out there and you're rocking and rolling and you're really aggressive about it. It takes over the lawyer's life too.
Absolutely.
If you're taking it seriously, which I always did.
Yeah.
I always made it for whatever reason. Maybe it's a sense of loyalty or whatever
Duty.
it is. I always took the client's cases very seriously.
Well, my dad was a criminal attorney here. I've said it before. And I mean, basically, he was, he had his yellow pads and his files and everything on his bed. I mean, he had a king-size bed, and they were scattered everywhere on his bed. And he was working day and night. He'd come home, have dinner, and he'd be working till 9, 10 o'clock at night, man. I mean, sometimes 11.
I used to work till 2 in the morning.
Yeah.
In fact, one of the lawyers that was working for me, still works with me. It's been more than 30 years. He's a guy that stays up till 3, 4 o'clock in the morning. You can't reach him until noon because he's sleeping.
Okay.
Yeah.
Well, my dad would get up at like 6 in the morning and then have to go to court.
This guy, this lawyer is brilliant. And he and I had, I guess, the same working habits. And I'd stay up till 1, 2 o'clock in the morning.
Wow.
And we'd be on the phone.
That's crazy.
I did it for a long time.
I know. Lawyers work their butts off. That's why I didn't become one.
Well, I think it's not that I'm overly sensitive about it, but I think we're not appreciated as much as we should be.
You're not. You got, lawyers get a bad rap, and let me tell you something. Lawyers are some of the hardest working people on planet Earth. I know. I lived with one. My dad was one. And you guys, and you take these cases seriously. You're not just there to just get a paycheck. You guys are grinding, man. You're grinders. Lawyers are grinders. You know what I mean? And
Depends on who you are.
Well, I mean, a good lawyer will grind and really put it out there for their client.
Well, the good lawyers are the ones that relate to the client's situation.
Right.
Not only from the legal standpoint of what you're going to do, but you have to recognize that these people are going through difficult times.
Yes.
Some people, I mentioned it before, they can't sleep at night, they lose weight. I have one client that got down to about 95 pounds, and it's because she just couldn't eat.
I dig. I mean, even when I went to People's Court, when I knew that the People's Court pays your whatever, if I would have been found, what would it be? Not guilty, but
no, you'll be not liable.
Yeah, liable. Found liable. They were going to pay for whatever liability would have been.
Well, that's how it works.
But still, even knowing that I wasn't going to have to pay a penny out of my pocket, it still stressed me out having to go to court and do this, even though I knew nothing was going to happen to me. In fact, I was getting paid to be on People's Court. Still stressful.
And how do you think Baldy the Clown handled it?
Well, he wore a wig. He lost and wore a wig on.
He wigged out on you. I know.
He looked like a fool. He looked like a fool.
Well, getting back to the demystifying, I started to think about it after I hung up the phone. I said, actually, what we're trying to do here, and we are doing it, is we are providing information for people who really want information. They really want to know how the system operates. They want to know, why are people indicted? What's the difference between an indictment and a complaint? Grand juries, by the way, are pretty much rubber stamps for the prosecution. It's a one-sided proceeding. What's the difference between them? People don't really know that. We make an effort. In fact, I got an email from a guy by the name of Larry from Boca Raton, Florida last week.
Oh, good.
And Larry said that he's been listening to the shows and he subscribes to a lot of law podcasts.
Okay.
And he really likes ours the best. And he went on and on and on. He said, but what he liked the most was that we talk in layman's terms.
Yes.
And I'm not talking about a lot of these things from an academic standpoint. If you want to do that, go to law school. But for us, we want the public to understand how it really works so that there's no unfamiliarity. When you mention a term like a leading question, what is the leading question? I'm going to tell you what a leading question is in a minute. People want to know that. They want to know, what do you do if you get served with a complaint? Putting aside small claims for the moment, because that's an entirely different and much more simple proceeding, lawsuits are very, very complicated. They can be very, besides being expensive and time-consuming, they can be very complicated, and the issues, most of the issues are unresolved, and they get resolved by some judge someplace as you go through the process. And so by telling people what things mean in lay terms and what they could reasonably expect. We were talking about the drunken judge not too long ago, a couple of weeks ago.
Yeah, that's right. That's right, Judge. You have to bring that up again.
Yeah, and they do it. And I was talking to somebody about a case today, as a matter of fact, where the judge did something which was outrageous. So somebody said, why did he do it? I said, because he wanted to. He could do it because he had the ability to do it. Was he wrong? He was 110% wrong. But he saw it the way he wanted to see it. He wanted certain people to get certain results. It was a criminal case. And he was definitely biased on the side of the prosecution. It wasn't a thing that could be done.
Yeah, that's the scary part. That's the scary part of going to court. And this is what you point out during the show, is that the system is semi-rigged in a way. And you know, the judges and a lot of these prosecutors and you know, some defense attorneys, they sort of, but it works both ways. It really does. So phase one of our show is really to educate the public in terms of information. Yeah.
Maybe you use it, maybe you don't,
right.
But at least you're going to know what it means from a layperson's standpoint. And the second part is that we use all these cases. They're all real. Why do I use these illustrations, these cases as illustrations? Because if it happened to somebody else, it could happen to you.
Yeah.
So if you've got these great expectations, oh, I can't, this is a walk in the park, this is a layup, this is a piece of cake, ain't so. And if you accept the fact that this could happen to you because it happened to somebody else, and you see it in a real case and you get an analysis by the judge that made the ruling, because people always ask me, well, why did you rule that way? Why did you feel a particular way with regard to a particular case? And people sometimes they shake their heads, really, they don't know what really goes through the thought process. But you don't know that as a litigant, what's going through the thought process of the judge either. And so this helps you understand and dampens your expectations.
Yeah. Well, like I said, and my dad was a criminal attorney. He always told me to respect the judge, to dress properly, just certain things in the courtroom to do. You know what I mean? If I ever had luckily I never did anything criminally, but I did have some things where I had to go to small claims court, things like that. And I always addressed the judge as Your Honor. I always wore a nice suit, you know what I mean? Maybe not with a tie, things like that. But, it's respect for the court, too. There's certain things and these are the things that you point out a lot during the show.
Well, it is true, because people always ask me, does it make a difference when you look at that? Because, you're sitting on the bench, you're sitting above. So you're looking down, really. It's designed that way.
Right.
And if I see somebody coming in small claims court with a suit on, they're a lawyer. Very few people come into small claims court wearing a jacket and a tie. Very few. Professionals mainly. But for the most part, they come in with shorts.
Yeah, I mean, that's disrespect.
Does it make a difference?
If somebody comes in, Judge, be honest here. If somebody comes into your small claims court and one guy is wearing, maybe not, I wouldn't wear a tie, but I'd wear like a sports jacket, nice jeans, nice shoes, things like that, brush my teeth, comb my hair, the whole thing. And you see some other guy in shorts and sandals in your courtroom, and they're going against each other. You don't have any bias at all. You don't have any thought process like, hey, this guy's respecting me and this other guy doesn't give a damn. No. Okay. I'm just curious.
No, but I can't say that there's not a subliminal effect.
Exactly.
From a conscious standpoint, it makes no difference, and you know that because you know what your job is.
Right.
But when you're looking at somebody coming in with shorts and sandals, like you say,
And going,
and
dude.
and the other person, hey, dude.
Hey, dude, judge, dude. Hey, I'm not guilty, man. I didn't do that, dude.
I don't think we've seen that. But the bottom line is that I think there's a subliminal effect. I wouldn't want to say that that's not true.
Right.
But the third phase here is for people who are really in the system already. They're in it. They inherited whatever the situation is. So you have to ask yourself the question, why? What are they doing this thing for? You know, in restraining court cases, which I handled for about 7 years, 7 years, mostly all ego issues. Small claims court, it's about the money.
Right.
And that's why I liked when I was given the choices between where I could sit. I remember over a period of time, let's say over about 8 years, I covered 15 courts in Los Angeles County.
Wow.
So I'd be in Pasadena one day, and I could be in Long Beach another day, and they'd send me out to Antelope Valley, which is 100 miles from my house, doing unlawful detainers.
Oh.
You know, I had some choices. I could say, you know what, I'm not available. I'm going to be out of town.
Right.
But I'm not doing L.A. County anymore because it was just a lot. And I'm happy where I am in Ventura.
Yeah, and you live out that way.
I'm 25 minutes from the courthouse.
There you go.
I like that very much. And,
Yeah.
a great court, by the way. I must say to the lay public, if you ever find yourself there, the people are so nice, so professional, and everything is done there with the right attitude. It's very little of the inside backbiting, whatever that you see in the system, because you think all the judges get along with each other. They don't.
No.
And are all the judges smart and wonderful? No, they're not. Are there some that are great? Yes, there are. But you have to be able to pick which one you're going to get, and you can't necessarily determine that in advance. Although generally you get assigned to one judge from the beginning of the case, and they get a sense of who you are, and you get a sense of who they are. But every now and again, they move you around. You know, judges change.
Yeah.
And you don't know what you're going to get. That's why I always say, settle your cases. There's no assurance you're going to win anything like that in any of these cases. And so the fourth phase, what we do is we try to mix it in, is, you know, a spiritual outlook. You know, why are these things happening to you? Nothing happens by accident. Nothing happens suddenly. Now, we've talked about the concepts of cause and effect.
Yes.
And we'll talk about motive because we're going to get to circumstantial evidence and actus reus, mens rea. Like those terms?
Sure.
Okay, we're going to...
Whatever the hell they are.
I'm going to define them because
Please do.
It's at the guts of all criminal cases.
Us laymen's need to know those terms.
Okay. You're going to get them today.
I can't wait. Hey, if you want to ask the judge a question, email him. AskJudgeHerb@gmail.com. AskJudgeHerb@gmail.com. We'll be back with Judge right after this.
NBC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
By the way, some of the people that have been contacting me are telling me that they've been watching the YouTubes. We've done, 25 YouTubes now?
21.
And they're very tolerable because they're like between 2.5 and 4 minutes. So
they're really good because...
And I give you a real good outline of what we do on the shows. So if you're interested in a particular subject, you just look at the index from the website where it says radio shows, and you click it. We describe what's on each one of the shows.
And what's the website?
The website is judgeherbdodell.us.
judgeherbdodell.us.
Yeah.
And then if you want to go to YouTube, just type in the judge's name, Judge Herb Dodell. And what's cool about the YouTube videos, 2 to 3 minutes long, maybe 4, some of them, but they're really informative. And you talk about a myriad of subjects. I mean, all sorts of different subject matter.
We don't go into any great detail because
No.
we can't, given the length of time that we have to do them. But we outline the subject matters pretty good. In fact, I wanted to mention I watched one of our shows not too long ago, and I said I had 2 cases to give you. I gave you the first one, which was the case against Richard Nixon, and I said I was going to give you the second one after the break. And then we took the break, and I asked you what was this, what we had talked about, and you were busy fiddling with the dials and everything else. So I never gave the second case.
Well, tell us what it is,
I'm going to
Judge.
tell you. It's a case. It's a guy you know.
Who is it?
His wife was on today.
Oh, my God.
Who do you think that was?
I have no
Former
idea.
president.
Was it Pat Nixon?
If they're here,
Ronald
we're going to
Reagan.
move down to Forest Lawn. It's not. No, it was
Bill Clinton?
It was Bill Clinton. The case was Jones versus Clinton.
Oh, geez. Paula Jones.
Paula Jones.
Yes.
And the question was whether or not a sitting president is subject to being deposed in a civil case while they're still sitting.
It's a yes, isn't it?
And the answer is yes. That's why when somebody raised the question, I remember who it was, maybe it was even during the interview with Stone, talking about will he show up if he's subpoenaed? Sure, he'll show up if he's subpoenaed, but the question is he going to answer any questions? I've said all along as a trial lawyer, there's no way I would ever let that client ever testify to anything.
Yeah.
Because it's a walking trap is what it is.
Let me ask a quick question. This whole thing now, every week it's something different with Trump and his administration. Now it's this week with the detaining the illegal immigrants and separating their families and things like that. Is there any law? Is there any can they file a lawsuit or?
No. In fact, I've said it so many times I don't want to keep repeating it, but I'm apolitical.
I know.
I really am.
Well, that's what's great about it.
Some issues I tend to be on one side, and other issues I tend to be on the other.
More people should be like you.
I don't just pull the lever for the same group every time because I'm that part of that group. I'm truly an independent voter.
So am I.
And I like that because it gives me flexibility.
Yep.
And so, you look at the law. We are a country that really survives based on the rules of law. And the laws go back a while. It's not this administration or the past administration or the administration before them. There's laws on the books. They're just enforcing the laws. There's nothing wrong with that in terms of the legality part. Is it emotional? Of course it's emotional.
Yes.
It's terrible to have to pull kids away from their parents. But the law is the law. And if you want to change it, go to Congress and change it, except this Congress doesn't do anything.
Right. Well,
this Congress or the last one. None of them in the last 10 years. They've done nothing.
Even with Bush, they did nothing too. It's crazy. It's been going on for years.
So we get into the next phase, which is the spiritual part of this.
Okay.
And in the criminal law, and we'll devote attention today to the criminal law.
Okay.
Because I was involved in the law enforcement part of this for a long time. And having defended many people in different circumstances, anywhere from the hookers on Sunset Boulevard.
I miss them.
Oh, they were great.
There were none down there.
Oh,
I went down to Sunset Boulevard. I went to the Whiskey on Saturday night.
Oh, really?
No hookers down there anymore. Nobody down there anymore.
It's online.
It's online.
And they don't take checks. We found out from that case that I had when I was in Torrance.
That is funny.
But most criminal cases require 2 elements. And even though we talk in layman's terms, I'm going to give you a couple of legal terms and then tell you what they mean.
Okay.
One is called mens rea, M-E-N-S, next word, R-E-A. And the other is called actus reus. Actus, A-C-T-U-S, reus, R-E-U-S. R-E-U, yeah, actus reus. One is intent, conduct, motive. That's called the mens rea. That's the guilty mind. That's what that basically means. And the other is called the actus reus, which is the actual physical act. And we used as an example not too long ago a case where my client was accused of transporting a substantial amount of cocaine in a box, which had a layer of glasses, and then it was a divider, and below the divider was all the coke. And it was a substantial amount of bags, real serious amount of stuff. His argument was, I didn't know, I was just transporting something. That's what he testified to. The prosecution brought in a witness who flipped, what that means.
Yeah, we do.
Who had flipped. That's the one we've told that story 3-4 times now. That's the one I ended up getting locked up in Chino by mistake during the riot.
Yeah.
But that was the case. And the bottom line was, if he didn't know what was in that box, no crime. Because it requires the knowledge and intent to do an illegal act. The illegal act was done. The actus reus, that was there. The physical part is usually not the difficult part.
Right.
The other part, the proving of motive and intent, and you can even think about in terms of a civil cases. Why are you filing a lawsuit? That's motive. Doesn't much matter what your motive is in the civil court, but it sure does make a big difference in the criminal court.
Yeah, for sure.
And so most of these cases that are successfully defended, and I've said it before, what you're looking to do is to establish some doubt, reasonable doubt. And what you're doing is you're attacking the lack of motive or intent.
So basically, the actus reus is the physical act.
Is the end result.
And that's what gets you arrested, isn't it? The physical act or the physical part of it, isn't that?
Yeah, sure.
And then the other part is sort of where the trial comes into play and to find them guilty or not guilty.
Well, sometimes people have the intent to do it, but it never happens.
Yeah, like if you're putting out a hit on somebody or something
and you don't do it.
Then you don't do it.
It's a separate crime because it could be a conspiracy.
Right.
And conspiracy, just so we can get back to what we were talking about a couple of weeks ago, is an agreement between two or among more than two people to commit a criminal act. But the second element is intent. So whether you commit the act or not, the intent was always there.
It was in your mind.
They're separate crimes. Yeah, in your mind, but if there's an overt act, what they call an overt act, such as I think we used the example of going out and buying ski masks because you're planning on robbing the bank. That's an overt act, unless you're planning on going skiing. No, and the argument I'd make if I was in that case is, did you have tickets to go to Mammoth next week? Yes, I did. And you paid for it all already? Yeah, I did. So why'd you buy the ski mask? Oh, because it was going to be windy, or whatever.
Yeah.
Trial lawyers, defense lawyers, have to be creative. Remember, you don't need to prove anything. So we get to the question of in circumstantial evidence. It's a series of events. I didn't want to mislead anybody last week when I listened to the show. I probably could have been a little bit more clear on what circumstantial evidence was. I mean, it was covered, but it could have been clearer. So I'm going to use a real case. So this is a real case. We may have even talked about this case, a criminal case.
Okay.
And my client was accused of burning down his business. And the week before he burned the business, he was accused of burning down the business.
Accused, Judge.
He was accused of burning down the business. Well, he got a not guilty.
Well, then he didn't do it.
I don't know if I'm going to jump to that conclusion, but
in the court of law,
and where it mattered
the most.
Where it mattered the most, and he had 2 priors, so he would probably facing a fair amount of time.
Life, maybe.
No, I don't know about that, but he was facing a fair amount of time. Anyway, the week before the place burned down, he had gone bankrupt. Number one.
Oh my God.
I'm going to give you a couple of facts. Second. He reported to the police that his license plate had been stolen from his car.
What, like a week
before?
The
fire.
Before, so?
Within the week.
Okay.
And he also reported to the police in a separate report that this person that he had been doing business with had threatened him, had come down to his business with a gun. That guy was now moved to London. He was gone, but he had made a report the week before. And the fourth piece of evidence was that an eyeball witness, now you're talking about direct testimony, what you see and what you read is direct testimony. Circumstantial evidence is a fact from which you were to infer another fact. If this happened over here and it happened over there, you take it as it goes and you unfold it as the evidence is presented. And so there was an eyeball witness, whose name was Michael, who was across the street from the building, and he saw the car parked, and a person coming out of the car walked over to the building, and shortly thereafter the place is burning, right? So that was the evidence. The prosecution claimed, number one, it was my guy because the license plate on the car was off by one number. And if he had gone bankrupt, obviously he had a motive, which really is, it's really to the contrary. He was already protected by the bankruptcy court. There was nothing going to happen to him.
Yeah.
And they also claimed that it was him, the guy described my guy. So if you remember the case,
I do.
It turns out, because this is all circumstantial evidence, right?
Right.
Except maybe the guy who sees a person.
That's the direct evidence.
It's direct evidence, but it's circumstantial in a way because it requires a description of somebody.
Okay.
And if it's a different description, then it's not the same guy. So in other words, when he described the person getting out of the car and walking across the street, he described that he saw the person underneath a sign that was hanging out with one of these strip malls. And my guy was 5'8". The guy that moved to England was 6'2", and I had measured the space. I went there and I measured the space between the bottom of the sign and the pavement, and I knew that if there was a lot of space between the top of this person's head and the bottom of the sign, it's a shorter person. Limited amount of space, small amount, it's a taller person. And I wanted to create the impression that it was the other guy that he saw. And so what was important about the evidence? Circumstantial evidence about the car license plate? Well, my guy had an explanation.
Somebody stole it.
Somebody took my plate.
Yeah.
It wasn't my car.
Right.
It was somebody else's car, but it had my plate on it. And so therefore that wasn't me. And then when it came down to the threat, and almost in every arson case, you're always looking to blame somebody else. You have to.
Yeah.
It's always somebody else.
Of course.
And so he had made a report about somebody threatening to kill him. So the argument was that was the guy. And the third, which we'll talk about right after the break.
Okay. It is from the for the people. Get Judge's book, From the Trench to the Bench, now on Amazon.com. And also, like I said, you can ask the judge any questions. Email him, askjudgeherb@gmail.com. We'll be back after this.
NBC Talk Radio, 1050 AM, KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Well, of course, the assumption that the prosecution was making was that it was my guy because he had gone bankrupt and his car had the license plate and whatever it is. And because that assumption is based on certain facts, by attacking those facts, if you can do that, you knock a hole in the conclusion. It doesn't necessarily mean if you can't prove one of them that the conclusion fails. Because we talked about, I guess it was during the interview with Roger Stone, as a matter of fact, the one question that he didn't answer, that he dodged, was whether or not if there was business dealings going on with the Russians and with the Trump people, whether that would constitute some criminal act. He dodged that. He doesn't answer hypothetical questions, is what he said.
Well, they're
But the way
acting
you
now.
deal with cases is you always ask hypothetical questions.
Right.
That's how you. Good lawyers will ask great hypothetical questions, and a good hypothetical question is the equivalent of what's called a leading question. Because I mentioned there's a concept in the rules of evidence called leading. You can't ask leading questions of your own witnesses. That doesn't mean it's a witness that you call. It's called direct testimony. You can't ask leading questions. I'm going to tell you what a leading question is in a minute. There's exceptions. The exceptions, if you're cross-examining, you not only can ask them, but you should ask them, because the answer is built into the question. That's what makes it a leading question. In other words, isn't it true that you were walking on Fifth Avenue at the time and you saw this burglary take place? The answer is built into the question. There was a burglary. It took place. It was on Fifth Avenue. Whatever. You're leading. It's basically the lawyer is selling the story and getting the words out of the mouth of the witness. And the fear was, if you ask somebody on direct testimony and you've prepared that witness, basically you're testifying and you're not supposed to be testifying.
Yeah, the
lawyer.
lawyer's testifying.
That's exactly what it turns out to be.
Yeah.
The cross-examination is different. In fact, you're allowed to impeach a witness. In fact, you ask loading questions. One of the favorite ones that I've heard before is, when did you stop beating your wife?
Oh, wow.
I mean, not that you're doing that in a typical case,
Yeah.
but that's the kind of question. It assumes that you were beating your wife at some point.
Right, exactly.
And you stopped.
Yeah.
But you got the point across, right?
Yeah.
And there are other times, and then people are saying, I couldn't have committed the crime because I was an epileptic and I couldn't do anything about it. Is that person liable? Probably not. Because what's missing? The mens rea. This was an involuntary physical act. But on the other hand, there's a Supreme Court case, as a matter of fact, that said if you knew that you were impaired and that you were at high risk, you shouldn't be driving. If it's an automobile accident, somebody gets hurt, and you can't say, well, I didn't intend to do it. Well, if you knew in advance you had a proclivity for that and it was a big problem, then you don't have that same argument. It comes up a lot. That's why many of these cases, the criminal cases that go up on appeal, are oftentimes based on the judge letting it in or not letting it in.
The evidence.
Yeah, and as I said before, I think it was last week, discretionary calls. You can't do much about a discretionary call unless you can prove that something is really out of whack. Yeah. So if you knock out a couple of things in the hypothetical offered by the other side, it dilutes the ultimate conclusion, because the argument is going to be, look, they said he did this and he did that, but they didn't prove that. And so you have to be very careful as a trial lawyer what questions you ask, because once you ring the bell, you don't get to unring the bell.
Yeah.
And sometimes you don't get the answers that you're expecting. That's why you're allowed to ask leading questions on cross-examination to affect the credibility of the witness who's testifying.
Well, you got to question the credibility, right?
Well, it's all about credibility.
Exactly.
And sometimes people say, well, if they make a good witness, does it make a difference? Absolutely. Most cases are decided on that term we just used, credibility. Is that witness somebody that should be believed or not believed? And that's what it comes down to on almost every case.
Right.
And that's the same reason I've mentioned at least a half a dozen times why you don't put your client on in a criminal case, generally. Because you take an enormous risk that if they don't come across credible on some issues, it doesn't have to be the main issue.
Yeah, they can catch them in any type of lie, right?
Done.
That's it. That's it.
But if somebody also asked me about hometown recently, said, does it make a difference where you come from when you're trying a case? The answer is sometimes it does.
Well,
I'm going to give you one quick example.
OJ.
No, I'll give you a quick example. I had a very, very close friend. We were really close friends. He was he was a judge at the time. And he lived across the street from the courthouse. There's a nice complex across the street from the courthouse. The trial judge that I had in this case lived in the same building. And they played tennis every lunch break. Every lunch break.
Oh, man.
So the first day I go in there, the opposing lawyer was from Sacramento. Nice guy from Sacramento. And I would come in the next, right after the half a day in the morning. I would say to this judge, I said, well, did Huss beat you up on a court this morning, And that was the name of the other judge.
Right.
And we developed this, I would say to him, how bad did he beat you? It was a schmooze. It really was a schmooze.
Yeah.
Who do you think got most of the discretionary calls? I did.
You did.
I did. Almost anything that came along, I got it. Was that dishonest or anything? Not really. He made judgment calls. Did he do it because he wanted to befriend me, or so he could tell my buddy on the court that he'd give me? Who knows? But it happens in reverse too. That guy was. The other guy was from Sacramento. Me, he was going to see.
Right.
Me, there was a contact with somebody. Was it something to recuse yourself over? Of course not. But the bottom line is there are so many intangibles and so many variables in trying cases, because we're talking about circumstantial evidence and conspiracy, things like that. There's so many judgment call rulings that it's really one big crapshoot. I keep saying it. I'm going to say it every week. Well, maybe not every week. You got to settle your cases. And that goes for criminal cases just as well. We've talked about that too.
But how if you're not guilty?
Well, but I remember. You probably don't remember. I prosecuted the insulin killer. His name was Smith. This goes back a long time. How much sympathy do you think he was getting? Not much. He was killing people over shooting him up. He was a doctor.
Oh, really?
Yeah.
And he's killing with insulin, not shots.
Yeah, that's how I remember it. And sometimes you get on the opposite side of it. I remember a gang case that I had. I was prosecuting a gang case, and the evidence really wasn't there. This was like in Alhambra someplace, and halfway through the preliminary hearing, it came to me. I said, there's no case here. I am moved to dismiss in the interest of justice, 1365 or 85, whatever the number is, and dismissed it.
You did the right thing.
Well, because you're supposed to do the right thing.
Exactly.
Does everybody do the right thing?
No. Hey, Judge, what happened with that case? We got to sort of wrap that one up where with the arson. What was that? What was the main thing? The guy's height or something?
Oh, yeah. He was 5'8". And when I had the guy testify on cross-examination, I said, isn't it true, Michael, I remember his last name, isn't it true that you only saw 2 inches between the bottom of the sign and the pavement, and the top of this guy's head? Only 2 inches, wasn't it? That's a leading question, isn't it? Of course it is.
Yeah.
And he said, yes. That was it. And I said, my guy, stand up, Mr. I don't want to mention his name.
Jones.
I don't want to talk about this guy. Because I told you, he stiffed me at the end of the trial.
Yeah, he did.
Didn't pay me.
He didn't pay me.
It took me 2 years to collect it back,
really?
Ultimately, through the bankruptcy court.
Wow.
But the bottom line, this guy was unappreciative. Look, the first trial, it was 2 trials. The first trial, I got a hung jury. It was enough to convince that jury that there wasn't enough to convict him.
Right.
The second one was 7-5 for guilty, and they made a mistake. I guess I should mention it because people haven't heard the show. They didn't know there could be a hung jury, and since they didn't have all 12, they voted not guilty.
How could they not know that there could?
Go figure it out.
I mean, wouldn't the judge give them instructions on that?
Of course he did.
And they just blew it off and didn't listen to it?
Whatever. I'm down the hall in the phone booth, and they said, the judge wants to see you. I told you to hold the story.
Yeah.
I come in, and the judge says, you know what? They made a mistake. I said, so be it. C'est la vie, as it goes.
It's too late.
And the DA, if he had polled the jury, would never have stuck because they wouldn't have had the verdict. They would have just said, you can't reach your verdict. Where do you stand? And whatever it was. And once they didn't poll the jury, I said, he's discharged. This is over. This is double jeopardy. And he walked.
Can the DA ever appeal a case?
Not that one.
Not that one, huh?
You could always appeal anything, but he had zero chance of winning it because the law is very clear. It's constitutional law, as a matter of fact. And so the reality is that everything is unanticipated, and good lawyers take into consideration and tell the clients, this could go south for you. this is what happened here, this is what happened there. And that's why some of the stories that are in the book, From the Trench to the Bench.
Available on Amazon.com.
Okay, yes, it is. In fact, you know what? I'm doing a rewrite right now. I've done some interesting editions.
Oh, cool. Cool.
It'll probably be out in a couple of weeks.
Oh, great.
But the bottom line really is that these things really do happen, and if you close your eyes, it's going to happen. It could happen to you, depending on what your consciousness is. You see yourself as a winner, you see yourself doing it for the right reason, or you change your attitude to make it the right reason. Results going to be different. It's like that movie. I use that example all the time. Your movie's done, but you can change the movie. How do you change the movie? Change your attitude, change your motive, change your intent, and watch what happens.
Think positive.
It's not only thinking positive, it's thinking realistically. It's coming out of the illusions and dealing with reality as it is. And reality is you can't predict the outcome. And if you could, that's a whole different story. But you can't predict the outcome. Now you can predict degrees of certainty.
Yeah.
You know, a team's in the Sweet 16 basketball or March Madness.
Golden State Warriors.
A 16 seed is rarely going to go very far.
That's true.
But it's not a guarantee.
That's true.
One of them got to the Final Four this time.
Yeah, they did. They did.
So they had more of a better attitude that they were going to win. And they went out there and with the limited ability they had, they went out and did that, or tried anyway.
You got to think like a winner to be a winner, I think.
100%.
Thank you.
Okay, so we'll be back next week, and we'll think of something interesting to talk about.
You will think about something.
No, but you always encourage me. That's what makes the show so interesting.
Hey,
it is. You're the main guy.
I'll
here.
stop, Judge. Hey, listen. Ask the judge any question. Email him, askjudgeherb@gmail.com. That's askjudgeherb@gmail.com. He'll help you out. He'll try to help you out. And
yeah, guidelines.
And also his book, From the Trench to the Bench, on Amazon.com. And YouTube videos, Judge Herb Dodell. He's got those YouTube videos are really cool.
They are, yeah, pretty good. You did a nice job in directing.
Well, I'm not talking about that. I'm just saying they're very informative.
They are informative.
You know, and you don't want to spend like 5 or 10 hours.
Oh, you know what
I
want to talk about? I'm going to talk about, we talked about cyberbullying and stuff before.
Yeah.
We're going to talk about what are you going to do today with what's going on, free speech versus restraints.
Okay.
Because you get into that when you do restraining order cases.
Write it down.
Okay. I'll remember.
Okay. All right. Take care, Judge. I'll talk to you next week. All right.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
So, you want to be in show business,